go to jail. Do we know how many days credit Mr. Hike has?
Yes, I just pulled it up.
It sounds like she's gonna come back here and maybe get right in the same scenario, but I hope not. I mean, her mother's here, her sister's here, her daughters are here. I don't know how she ended up in, do you know what it is? She was accused of burning in Indiana?
I think it was a car, but I
Oh,
can't
car. Yeah, that's not good. Yeah, you told me that and I forgot.
March 10th, so we might have 15 days. 16 days. You want to count the 10th, or today rather?
Good morning, Mr. Hike.
Good morning.
This is file number 231760. Yes, 23. This case is about 3 years old, and we'd really like to bring it to a closure. That's entitled People versus Bo Thomas Hike. That's you, sir?
Yes, sir.
And I've known you since you were in middle school. You're here today on this charge of failing to complete your probation and a domestic violence charge. The PV petition alleges that on or about 9/27/23, you were placed on a 12-month probation. You're supposed to report on a monthly basis and complete anger management. You'd reported for a while, but we never got the anger management completed. You were working a union traveling job. And so we had a probation violation hearing that was set for November 13th of 2024, and you didn't show up. So bench warrant issued, and you got picked up on the bench warrant. On March 10th, I just entered a not guilty plea, canceled your bond, and tried to set a hearing as soon as I could. The problem was we had difficulty coordinating with Ms. Ives' schedule. By our calculation, you've been in jail today for 16 days. Mr. Huff's recommendation, if you were convicted of the probation violation, was to revoke or cancel the probation, lose the deferral status, and just order time served and remaining fines and costs. I'm not going to try to drag you over the finish line for anger management, although frankly, I think you could have benefited from it. So if you admit to not completing anger management and not reporting, I'm going to give you credit for time served, let you out of jail, and revoke your probation, and waive your remaining fine and costs. As I told Ms. Roars in the last hearing, you do have a right to have a hearing where it must be established beyond a preponderance of evidence that you did violate the terms of your probation. And you have a right to have a hearing under oath with representation by a lawyer. But I told you what I plan to do if you do admit the violation. Do you understand?
Yes, sir.
All right. Are you going to acknowledge that you did fail to complete anger management
Yes, sir.
and you went under the radar for a while?
Yes, sir.
I wasn't really clear. I knew this warrant was out. As I said, I've known you and your brothers and your family since you were playing high school sports. But you didn't really go anywhere. You were just sort of under the radar.
That is correct, sir.
And then in order to get this over, you just turned yourself in to resolve it.
Yes.
All right, at that point, I didn't think it was gonna take 15 days to do it, but, yeah, 16 days. All right, are you gonna be back at Shorewood Drive?
Yes, sir.
Do you still have your union job?
Yes, sir.
Do you have an assignment when you get out?
No, I just have to call her and get one.
You're no longer in a relationship with this complainant who was Angela, is that correct?
That is correct.
And you don't have any children together,
No,
so you don't have any further contact with her?
no.
I wish we could have done the anger management and the deferral, but we didn't. And I'm not gonna accomplish any more by letting you sit in the jail longer. Ms. Ives, you have any additional input?
I don't, Your Honor. I think that my client needs to move forward with his life. Hopefully, he realizes the significance of it and modifies his behavior going forward.
I think that's probably gonna happen. I don't think I'm gonna see him again. Mr. Huff, anything to add?
No, wish you the best of luck.
Somebody gonna pick you up?
Yes, sir.
All right, here's the deal. I accept your admission to the violation that you failed to complete the anger management and failed to report. I revoke your probation. I'm giving you 16 days jail credit, 16 days, waiving any remaining fines and costs, and there is a loss of the deferral status. But otherwise, you're free to go. You can call somebody and they'll come pick you up. How about if you don't come see me? I'll be here for the rest of the year. So if I run into you at McDonald's or the Myers or something, but how about not in here?
Sounds amazing, sir.
All right, you're good to go, Mr. Hike. I'm sorry this took so long.
I'll be back for a while.
Oh, that's a 19.
Priscilla, you're here for the,
Prostitution hearing and then a.
oh, the restitution hearing got adjourned because Angelique is at prosecutor training.
Oh, I was not informed.
Well, I just signed it about an hour ago.
Oh, okay.
I had it, but I hadn't, it was laying there.
Was my guy?
I think so. Yeah, the attorney, the prosecutor knew about it and the attorney knew about it.
Okay.
Everybody but you knew about it, so.
Yeah, that's okay, you go fix my computer.
Your Honor, I have an 11 o'clock matter, Miss Kaylee Ruth.
Yes,
She has emailed me she's been undergoing some medical health problems.
we got a call yesterday from somebody telling us that she's having some significant pregnancy-related health issues.
Yeah, she sent me some medical documentation, though it's not, she doesn't exactly have an appointment today, but it sounds like she's been in medical treatment and she's got a follow-up appointment in 2 weeks. She said she's been in pain and bleeding. The photos aren't very clear, but it certainly looks like she's been in treatment at Bronson OBGYN in Kalamazoo. It appears that the documents have her name on them. It doesn't really say what it's for, and I wouldn't feel comfortable putting that on the record. I just would ask the court.
Well, let's see if because she is pregnant and this is a methamphetamine case,
Mhm.
I want to have contact with her. Those two things do not go well together. So we'll see whether she does show up.
Okay. I will give her a call and let her know that the court
but-
still expects her to be here at this
Yeah, I
time.
want to see how she's doing. If she is at a medical appointment, we can adjourn it. But the fact, one of the things I'd like to do is test her to make sure that she isn't still using during her pregnancy. And so that's why I didn't want to just adjourn it based on a phone call from somebody.
Very well, thank you.
All
I'll get
right.
a hold of her, Your Honor.
All right, thank you. All right, we're going to stop the record in the live feed. You want to sit here and watch me look at my screen? We'll be back.
3 years. That's how long this case had been sitting on the docket. A domestic violence charge, a probation violation, and a man who quietly slipped under the radar rather than face the music. But here's what made this hearing different. Beau Thomas Heike didn't run. He turned himself in. The original terms were straightforward: 12 months of probation, monthly check-ins, and completion of anger management. Heike reported for a while, kept his union job, stayed out of further trouble. But the anger management never got done. When the probation violation hearing came around in November 2024, he was a no-show. A bench warrant was issued, and eventually, he was picked up. What followed in that courtroom was a moment of genuine judicial nuance. The judge, who had known Heike since his youth, didn't reach for maximum punishment. Instead, he sized up the situation honestly. More jail time wasn't going to accomplish anything. Heike had already served 16 days. He had a job waiting, a stable address, no ongoing contact with the complainant, and no shared children to complicate things further. The ruling, probation revoked, deferral status lost, 16 days credited as time served, fines waived entirely. Walk out the door, and don't come back. It's a resolution that won't satisfy everyone. The anger management was never completed. The original domestic violence charge lingered without full rehabilitation, but the judge made a pragmatic call: close the file, cut the cost, and give a man the chance to rebuild. Sometimes the courtroom isn't about punishment. Sometimes it's about knowing when enough is enough. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.